Welcome and good morning. My name is Joyce Harris, and I am the Director of the Region 10 Equity Assistance Center located at Education Northwest in Portland, Oregon. I'll be moderating today's webinar, Title IX, Preventing Harassment and Sexual Violence. Before we get started, I'd like to review a few technical items. First, this webinar is being recorded. A link to the recording and to the presentation slides will be available on the Education Northwest website within 2 weeks. We'll provide the URL for this site as soon as the webinar is posted. Second, we have muted all phones to minimize background noise. And lastly, our webinar will begin with 2 presentations from 2 researchers, Dr. Bill Howe, State Title IX Coordinator for the Connecticut State Department of Education, and Ms. Marta Larson, who spent 28 years as a program manager for the Region 5 Equity Assistance Center that was located at the University of Michigan. The presentations will be followed by a brief question and answer time when you can pose questions to any of the presenters. Please type your questions into the chat area located at the lower right-hand corner of your screen. We will address as many of these as we can during the question and answer session. I'd like to start by first acknowledging Kathy Rigsby, who is the Director of the Region 8 Equity Assistance Center located at Metropolitan State University in Denver, Colorado. Kathy was very instrumental in helping us to conceptualize this webinar, offering suggestions of possible speakers, and providing us with some great input on the topics that should be covered. I want to thank you because this is one of the collaborations that is very frequent amongst the 10 Equity Assistance Centers. Our presenters today are Dr. Bill Howe, a leading expert on culturally responsive education, multicultural education, bullying and harassment, and gender equity. As the Connecticut State Title IX Coordinator, he has firsthand knowledge of practical strategies to help schools prevent and respond to harassment and sexual violence. Howe is co-author of Becoming a Multicultural Educator, Developing Awareness, Gaining Skills, and Taking Action, a book that will be released in 2014 by Sage Publishers, and the Handbook for Achieving Gender Equity Through Education, 2nd edition. He also serves on the Connecticut Asian Pacific American Affairs Commission and was past president of the National Association for Multicultural Education, NAME. Our other presenter, Marta Larson, spent 28 years as a program manager for the Region 5 Equity Assistance Center at the University of Michigan. In that position, she focused on race, gender, and national origin equity and specialized in developing and implementing programs related to Title IX, harassment prevention, STEM, parent involvement, and equitable school discipline. In 2011, she was named Educator of the Year by the Wisconsin State Human Relations Association. She now works as an independent consultant, manages the Michigan Girls Collaborative Project, and serves as the business manager for the Association for Gender Equity Leadership in Education, or AGILE. So I first want to start out just talking about the mission of the Equity Assistance Center. There are 10 regional centers that are funded through a grant with the U.S. Department of Education to provide training and technical assistance to public school districts in the areas of race, gender, and national origin upon request and at no cost. One priority of the Region 10 EAC is to assist schools to create safe school climates by preventing and responding to harassment, bullying, cyberbullying, and hate crimes by educating all school staff and administrators, students, parents, and community. So how does the EAC assist schools? We provide professional development, conferences, webinars such as this one, and resources to prevent and respond to harassment and sexual violence. We assist schools with policy and procedure development and revision, and provide trainings to both students and staff and parents. We assist schools to comply with Office for Civil Rights compliance agreements, and we partner with the Office for Civil Rights in our region, the Department of Justice, Community Relations Services, and State Departments of Education to assist schools. To begin to frame some of the legal obligations that schools have related to Title IX and making sure that the civil rights of students are protected, there are several key federal anti-discrimination laws that I'd like to highlight. Title VI of the Civil Rights Act of 1964, which prohibits discrimination in public schools on the basis of race, color, and national origin. Title IX of the Education Amendments was enacted in 1972, and it prohibits discrimination in public schools on the basis of sex. The last act is the most recent, the Matthew Shepard, James Byrd Jr. Hate Crimes Prevention Act of 2009. This act prohibits crimes committed because of the actual or perceived race, color, religion, national origin, or sexual orientation of any person. Title IX of the Education Amendment states that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance. This was adopted in June of 1972, and it was part of the Civil Rights Restoration Act that was reaffirmed in March of 1988. So who is covered under Title IX? Men, women, boys, girls, staff, students, state and local education agencies receiving federal educational department funds, charter, magnet schools, vocational and technical schools, colleges and universities, some for-profit schools, and libraries and museums. Requirements under Title IX include a self-evaluation, the assignment of a Title IX coordinator, record keeping, policy development and dissemination, and grievance procedure development and dissemination. Another important aspect of looking at Title IX and what the legal obligations are may be found in several Dear Colleague letters, but we're going to focus on just a few this morning. OCR issues these letters as significant guidance documents to assist recipients of federal financial funds with information to meet their legal obligations. The intent of these Dear Colleague letters is to provide members of the public with information about their rights under the civil rights laws and regulations that are enforced by OCR, and to provide information and examples to recipients about how OCR evaluates whether recipients are complying with their legal obligations. The Dear Colleague letter that I'd like to focus on is the one on Title IX and sexual violence. This guidance was issued on April 4, 2011, and reminded recipients of the following, and I quote, "The sexual harassment of students, including sexual violence, interferes with students' right to receive an education free from discrimination, and in the case of sexual violence, is a crime. Sexual harassment of students, which includes acts of sexual violence, is a form of sex discrimination that is prohibited under Title IX. Title IX requirements pertaining to sexual harassment also include sexual violence. Sexual violence refers to physical sexual acts perpetrated against a person's will or where a person is incapable of giving consent due to the victim's use of drugs or alcohol. An individual also may be unable to give consent due to an intellectual or other disability. Sexual violence includes rape, sexual assault, sexual battery, and sexual coercion. These acts of sexual violence are forms of sexual harassment covered under Title IX. Title IX protects students from sexual harassment in a school's education programs and activities. In academic, educational, extracurricular, athletic, and other programs of the school, whether those programs take place in a school's facilities, on a school bus, at a class or training program sponsored by the school, at another location or elsewhere. For example, this would include protection for a student who is sexually assaulted by a fellow student during a school-sponsored field trip. The other dear colleague letter that I want to call to your attention this morning is the one on Prohibition against Retaliation, which was released on April 24th, 2013. And this is taken directly from the dear colleague letter. The federal civil rights laws make it unlawful to retaliate against an individual for the purpose of interfering with any right or privilege secured by these laws. If, for example, an individual brings concerns about possible civil rights problems to a school's attention, it is unlawful for the school to retaliate against that individual for doing so. It is also unlawful to retaliate against an individual because he or she made a complaint, testified, or participated in any manner in an OCR investigation or proceeding. Thus, according to this particular guidance, once a student, parent, teacher, coach, or other individual complains formally or informally to a school about a potential civil rights violation or participates in an OCR investigation or proceeding, the recipient is prohibited from retaliating. This includes intimidating, threatening, coercing, or in any way discriminating against the individual because of the individual's complaint or participation. OCR will continue to vigorously enforce this prohibition against retaliation. So how does OCR respond to a complaint that it receives? The complaint is reviewed and an investigation is launched to determine if the incident is a civil rights violation and how the school or district responded. Students, parents, and school staff are interviewed and documents are reviewed to determine if the complaint falls under illegal harassment. After the investigation is completed, OCR issues a letter of findings to the district. If there are no violations of civil rights law, the case is closed. If there are civil rights findings, however, OCR will issue a settlement agreement of what the district must do to come into compliance. This agreement will include a timeline for completion and is very explicit in the different things that the district must do to gain compliance. The analysis that OCR uses to review complaints is based on these following factors. The behavior violates federal anti-discrimination laws for illegal harassment based on these criteria. It is unwelcome, unwanted, causes harm, or is severe, and is repeated, meaning that it's pervasive or persistent. The behavior is based on federally protected categories of race, sex, or national origin. And finally, the behavior is connected to the school environment. At this time, I'd like to turn it over to our first presenter, and that would be Dr. Bill Howe, who will talk to you about Title IX and harassment.
I want to thank Joyce Harris and the Equity Assistance Center for organizing this event. Title IX and all that encompasses has been an extremely important law, and there are a lot of issues that are going on now in K-12 as well as higher education around the area of sexual harassment and sex discrimination that are extremely important. So this is very timely, and thank you again to the Equity Assistance Center for running this event. I want to start off by mentioning a couple things in terms of the law, and that involves money. The average Title IX lawsuit settlement is $200,000. That's a huge amount of money for any school to bear, and that's not counting all the legal fees and whatever that were needed in order to deal with the complaint. So just from a fiscal perspective, with schools in such tight budget constraints these days, it is extremely important, not only for the welfare of students and staff, but also in terms of your budget to be in compliance. The second area of people should be aware of is that the Department of Justice has been very active in the last several years in prosecuting complaints around Title IX. So even the Office for Civil Rights will say you do not want to get the Department of Justice involved, because when they do, it is serious, and they are extremely aggressive around this area. And we are very grateful for them, both the U.S. Department of Education and the Department of Justice, for the work they do, because it has led to better protections for staff and students. So let me start by going over briefly some of the hot issues around Title IX that sometimes people tend to forget or tend not to make the connection. So briefly, let me just talk a little bit about bullying, cyberbullying, sexual violence, transgender issues, and single-sex programs. These are some of the more hotter topics that schools are facing. Let's start with bullying. Bullying is certainly getting all the press, getting all the attention these days. It's hard to watch television or read a newspaper without reading something regarding issues and acts of bullying. I believe, if my facts are correct, all but one state has bullying legislation. So if you know you're that one state, I strongly suggest that you lobby to get that law passed in your state. In 2010, the U.S. Department of Education Office for Civil Rights issued a Dear Colleague letter because of their concerns that people were focusing too much on the definition, the act of bullying, and forgetting that bullying is a form of harassment when based on a protected characteristic. And there are protections under Title IX against bullying, and also anti-gay harassment is also covered under Title IX. I think many of us are focusing very clearly on bullying, the definition of bullying. It's important to understand that many acts of bullying can also violate other laws, so that's important to take into consideration. For those states that have bullying specialists, they should work very closely with Title IX coordinators to ensure that they are investigating complaints fully. Second issue that's also getting a lot of press is the issue of cyberbullying. With the advent of social media, Facebook, Twitter, and all the other programs that we can't even keep track of, students are unfortunately not understanding that whatever goes on the internet stays on the internet. That whatever you write, whatever you put on there is available for people to read all over, and it's also something that can't be taken back. I like the analogy of once you squeeze the toothpaste out of the tube, you can't get it back again. So it's important for people to understand what cyberbullying is, and also for those of us who may have grown up before the internet era, we need to understand Facebook, we need to understand all the social media, we need to understand how that works and be proficient in it. There are 36 states now that provide provisions in the education codes prohibiting cyberbullying or bullying using electronic media. Joyce Harris mentioned sexual violence. It is a major concern, not only in K-12 but also on college campuses. The requirements of Title IX require that schools take action and put issues, procedures in place to prevent and also respond to acts of sexual violence. So schools have an obligation to respond to sexual violence. It is not something that you leave just to police departments. Schools must keep in mind that there are several procedural requirements that need to be in place. One is a notice of non-discrimination. Although it may seem obvious, it isn't obvious to a lot of people that they must understand that sexual violence, sex discrimination is illegal, so there must be a notice of non-discrimination, and we'll talk more about what that means and where that takes place, but all staff, employees, students must be notified of the policy of non-discrimination. Every educational entity must have a Title IX coordinator. One of the games that I like to play when I visit schools is to stop people randomly and ask, who is your Title IX coordinator? You should be able to get immediate responses. I kiddingly tell Title IX coordinators when we do training to test how effective and pervasive your program is, to call back to the school someday and disguise your voice and ask for the Title IX coordinator and see if the person answering the phone first knows what Title IX is and then also knows who the Title IX coordinator is. And the third procedural requirement in this topic is we have to have grievance procedures. They must be published in both the employee handbook and student handbook, and they must spell out very clearly what the process is for handling complaints. Single-sex programs also have gotten a lot of attention, and the caution here is that both Title IX and the U.S. Constitution set limits on when single-sex programs or schools are permissible. The research is very clear, though, that there is very little evidence that single-sex programs are effective. Many programs that are created are not following the proper guidelines. And part of the difficulty with single-sex programs, if they are implemented, are that students are often excluded from programs from which they may benefit solely based on their gender. Secondly is that single-sex programs can reinforce gender stereotypes that are harmful to all students. And then thirdly, girls have historically received and will likely continue to receive fewer resources and opportunities in all-female environments. Again, the U.S. Constitution regarding single-sex programs, what to understand here is that single-sex programs will survive constitutional scrutiny only if they are substantially related to an exceedingly persuasive justification and they provide equal opportunity to the excluded gender. In other words, you cannot create a single-sex program just because you want to. You must have a reason for it. You must have research to back it up. You must have a curriculum and a program that's well thought out and gives very clear description of what you will do differently and why in your single-sex program. It's important to note that the American Civil Liberties Union has been prosecuting several programs in several states because they have impermissible single-sex programs. So please enter this with caution. There are programs that can be effective, but unfortunately there are programs that unfortunately continue to discriminate against the excluded gender. Third area that's also becoming increasingly important, and the U.S. Department of Education on October 26th pointed out that while federal law does not protect against harassment based on religion or sexual orientation, they do include protection against harassment of members of religious groups based on shared ethnic characteristics, as well as gender and sexual harassment of gay, lesbian, bisexual, and transgender individuals. Well, Title IX has a much broader reach than many people realize. And it's significant to note that the Department of Education is trying to educate people in the law. So here's an important graphic to understand. Since so much attention is focused on bullying, too often offenses are investigated solely on the definition of bullying. And what's important to remember is that in many cases, bullying can also be a civil rights violation, it can be a harassment, it can be a criminal act, and also can be a violation of school policy. For example, having a student stuffed into a locker and left there. Unfortunately, a common high school or even middle school prank, putting someone into a locker can be a bullying offense, but it's also important to remember that if any of us were stuffed into our trunk of our car and left there overnight, we could have that offender charged as under a criminal act. Something as simple as stealing someone's lunch money. In the real world that we live in, if someone is taking your money every day, we call that extortion. A good school resource officer will work with students to get them to understand the severity of bullying, and how, in many cases, it can be a criminal act. Not that we want to criminalize bullying, we just have to make sure that there's a clear understanding that some things are bullying, but also some things can fall into other categories. So, with that overview, I want to lead into the part of the presentation that involves what I do on a regular basis, and that's handling complaints. I try to tell schools that when I call you, please don't get upset, please don't pass out, please don't cry. When I'm calling you from the State Department of Education, my job is to try to help you understand what the complaint is and try to help you resolve it without it becoming a civil rights violation or worse. So what's important to remember is, if you are investigated by the Office for Civil Rights, they are going to ask you two questions. One, do you have a policy on handling complaints? And two, did you follow your policy? This is a very clear intent on their part. The Office for Civil Rights is very much concerned with, do you have policies and procedures in place that effectively handle complaints? If you do, they will fault you less if you didn't do it well, but they will find a great deal of alarm, and their letters of compliance will be much more stricter and much more thorough in making sure that you do comply in the future. So please remember and ask yourself, do you have a policy on handling complaints? And do you follow your policy? If you don't know what your policy is, and it's supposed to be in the employee handbook and in the student handbook, please dig it out now after this presentation and read it. For those of you who handle complaints, print it out, tape it on the wall in front of your phone, and make sure that you follow it whenever you get complaints. Speaking of complaints, when I work with schools, I walk through a litany, a checklist of things that they need to have in place to prevent issues, but also they need to have things in place in order to handle complaints effectively. So let me go through this checklist with you, and you might make a mental note yourself if you have these in place. Imagine receiving a complaint from a parent, employee, whoever, on a violation, whether it be Title IX or anything else. So this is the checklist. It's not an exhaustive checklist, but it is something that I have found extremely helpful in getting people to make sure they walk through the correct steps and aren't missing anything. This is a quote, citation directly from Title IX. Do you have a responsible employee who is the district Title IX coordinator, and have you adopted a grievance procedure? And that's the first step that's important. You must have someone that's responsible, and they must be trained in Title IX. Every educational entity has to have at least one person who is the designated Title IX coordinator, and they are responsible for overseeing the handling and investigation of all complaints. Secondly, have all your students and all your employees been notified of the names, office addresses, and telephone numbers of the Title IX coordinator? Grievance procedures for students and grievance procedures for employees, you must have one, and it must be published in your employee handbook and in your student handbook. I recommend, too, that you place this on your website, and also as a note about websites, I think most of you know that on websites there's a search box that you can type in when you're looking for things. Get your web person to put in keywords or meta tags so that if someone types in Title IX or sexual harassment or bullying or sexual assault, that they'll go directly to your policies and procedures. You want as much transparency as possible. your policy. You have to have a strong and wide definition and dissemination of your policy of non-discrimination on the basis of sex. It must be included with all and available to all applicants for admission and employment. All students and parents of students must be aware of your policy. All employees must be aware of the policy. Anyone who's referring students or people to your educational entity or the ones you refer to must be aware of your policy. And of course, all your unions and your professional organizations need to know the policy. Now, to have a policy is great, but you have to get it out so that people are aware of it. Title IX requires that your notice of non-discrimination has been placed in your local newspapers, your school newspapers and magazines, in any memoranda or any other written communication that you distribute annually to each student and employee. The policy, the notice of non-discrimination must be in all announcements, bulletins, catalogs, students, and faculty handbooks in all application forms. If you are investigated by the Office of Civil Rights, this is one of the first things that they will look for. They will go through all of your written material to see if it is in place. So keep in mind, anything that you publish as a publication of your school district must include this non-discrimination policy. You also have to ensure that all of your publications are free of any language or text suggesting that you prefer or have preferential treatment for one sex or the other. Your admission and recruitment folks, including counselors and student advisors and personnel officers, all are clearly aware of your non-discrimination policy, and they adhere to the policy. All right, so you've that's the preceding was the procedural policy things to have in place. All right, now you've received a complaint from a parent or guardian. Someone has lodged a complaint with you. Parents and guardians and alleged victims should be informed of their rights. When I receive complaints, that's one of the first things they ask me is, tell me what my rights are. So it's important for you that you provide to them a copy of your non-discrimination statement, a copy of your complaint procedures so that they know what you're going to do and how long each segment of your investigation will take. Let them know of their rights and the process for appeal in case you do not agree with the initial complaint. Make sure you provide contact information for all school officials that are charged with investigations. It could be the 504 person, it could be the person who handles Title VI complaints. Anybody in your school that handles complaints, provide them with their information also. Often, it can be a Title IX as well as a Section 504 or ADA complaint, which will involve possibly another person. In the interest of transparency, too, make sure you provide the contact information for all your state and federal civil rights agencies, your state civil rights group, as well as the U.S. Department of Education. Police contact information is important. Some cases of bullying, harassment, Title IX violations are also criminal. So please make sure that they have information on how to contact the police. Some acts of discrimination, assault, are also violations of child welfare laws. So please make sure that the individuals know who to contact should they feel that it's a child abuse complaint, and also State Department of Education officials that can provide technical assistance. Secondly, as you're going through your procedures, once you've received the complaint, just double check that the non-discrimination statement is in all official publications. Make sure that your non-discrimination statement includes all protected classes. This is something that schools often fall down on. When you start listing protected classes, you must list them all. So make sure you include every protected class that your state requires you to have. Also, number 4 on this list, your non-discrimination statement must include the name, title, address, and phone number of the Title IX and 504 coordinator. Now, when Title IX was passed in '72, the internet wasn't around yet. So the Office of Civil Rights is also recommending now that you provide email addresses for individuals. Again, we're following along this checklist of things schools should have in place to make sure they're protected against complaints. Do you have signed attendance sheets for all your staff proving that they did attend training on Title IX, bullying, and other similar policies? Have those attendance sheets available with copies of the signatures so you can prove that everyone has been trained. At the same time, make sure that you can verify that all students have been educated in the bullying policy, in Title IX, and other similar policies. And then number 8, there needs to be a log of all complaints. If you cannot produce a log, it's going to be a suspect. Make sure that you have files on all your complaint investigations, because all these, may be have to be made available to investigators. Make sure that all complaints are investigated in the context of possible violations of federal and state civil rights laws, criminal violations, child abuse guidelines, bullying laws, and school policies. Here in Connecticut, the Office of Civil Rights last year investigated 3 school districts who had been treating complaints as bullying when they were in actuality also Title IX complaints. So make sure you have that broader lens. And it's also extremely important to know that parents and guardians under the Freedom of Information Act may receive a copy of the complaint resolution, of course with all the identifying information redacted. And I'm also very happy that Joyce Harris mentioned this in her section, that alleged perpetrators and victims are reminded about policies against retaliation. Every initial interview should remind people that retaliation is a severe act and will not be tolerated. The Office of Civil Rights takes a very dim view of schools that allow retaliation to occur. Number 13, as a result of investigations, there need to be safety plans created, because part of a civil rights investigation is to try to prevent this from happening again. And then finally, number 14, in civil rights parlance, what we try to do is make the victim whole again. And one of the things that is important to offer is counseling to both alleged perpetrators and to alleged victims. So I hope you find this checklist helpful. If you follow this, it will put you in good stead in preventing and preparing for handling complaints. The Office for Civil Rights will look positively on you that all these things are in place. So to continue on with the more detail about Title IX, I want to turn it over to my good friend and colleague, Marta Larson. Marta has been in the business a long time, and I consider her a good friend and mentor and an expert in the field. So please welcome Marta Larson.
Thank you, Bill. I really appreciate it. I always learn something new every time I listen to Bill speak, and this was no exception. Thanks a lot. I'm going to start by, actually, Mitch, I'm not able to, I'm clicking in the window and nothing's happening for my slides. I'm going to start by talking about Title IX in some specificity in terms of areas that it applies to in addition to athletics. I think that in terms of athletics, there we go. In terms of athletics, I think everybody has quite a bit of information already about Title IX, and sometimes it seems that people actually focus on athletics and don't notice some of the other areas of Title IX. So I want to talk about some of those other things. Admissions refers to any school or program that considers applications on the basis, on any basis other than the location of the individual's residence. So admissions is an important part of Title IX. Title IX covers access to courses and programs. Some of them are listed here: physical education, career and tech ed, STEM, higher education, standardized testing, technology. I would add to that also, though, gifted and talented and special education. In all these areas, you can assess your compliance with Title IX by comparing your enrollment statistics in those particular courses or programs to the statistics for the population in question. I think it's also important to recognize that if you have an after-school program, Title IX also applies to that. I've run into after-school programs where the vendors that are providing programming were excluding girls from drumming classes and boys from hair braiding classes are 2 examples of things that would be violations of Title IX. Under counseling, that refers to the course of study that the student is engaging in. It also can refer to special training, the kinds of tests and appraisal instruments that are used. There used to be tests and appraisal instruments that gave different results based on the student's gender, and those are prohibited. Rules and policies refer to rules, behavior, and disciplinary consequences. I think sometimes rules are applied differently to boys than they are to girls, or the rules and policies that are adopted have a disproportionate effect on one or the other gender, and both of those things are not permitted also under Title IX. Treatment of students refers to things like pregnant and parenting students. I have a friend whose 16-year-old daughter became pregnant accidentally, and he was telling me that he was very happy because the school was so nice to let his daughter stay in school even though she was pregnant. And when I informed him that she had a right to stay there and they were doing this not only because they were good people but because they were following the law, he was stunned and had no idea. And I think this is something that people need to be aware of. Learning environment under treatment of students refers to things like response opportunities in class, whether the students are called on equitably, males and females, to the extent possible, the kinds of approval and attention they receive in class. Those are some examples of learning environment. Financial assistance and student housing often does not, come up when it relates to K through 12 education, but when it does, it often refers to things like scholarships. If there's an athletic event or some sort of club event where there's an overnight stay involved, those sorts of things need to be equalized between males and females. Co-curricular and extracurricular activities refers to things like clubs and field trips, that they are not being limited in any way from participating based on their gender. Employment practices refers to things like pregnancy and parenting, but it also refers to things like some schools, I think probably not so often now, but in the past had the practice of linking teaching openings to coaching spots, and they had a certain gender in mind for those particular coaching spots, and that's not okay under Title IX. And I think finally it's important to notice under sexual harassment, which is what we're focusing on mostly today, that that includes things like off-campus sites, co-ops, job placements, those sorts of things. So if a student is placed in a position off campus, it can't be on the basis of gender, and they can't be harassed while they're there. So now I'm going to turn my attention to the Title IX coordinator, the roles and responsibilities of the Title IX coordinator. And I think it's important to recognize that it's not always necessary for the Title IX coordinator to be the investigator for complaints, but if they are, both of these things apply. Both the Title IX coordinator and the complaint investigator need to have the following characteristics, and it may be possibly more manageable for the school or school district to assign a different person to investigate as opposed to do the Title IX coordinator role. So the Title IX coordinator and the complaint investigator both should be district administrators or quasi-administrative, because very often they need to be able to request records or get information, and they should not have to go through a large, lengthy chain of command to get that information. Both should be knowledgeable, both about Title IX and about the district policies and procedures, so that they have no confusion as to what's okay and what's not okay. They must be able to take a developmentally and culturally sensitive approach so that they're not responding wrongly to possibly culturally different ideas about physical space, touching, eye contact, and other forms of interaction. They also need to be able to deal with individuals that are very young in a developmentally appropriate way. I think there's a lot to be learned from the police approach in which they recognize that it's possible to ask questions of children in a way that's not leading them to some sort of conclusion. The Title IX coordinator and the complaint investigator need to be neutral fact finders. I think sometimes when I encounter people that are newly Title IX coordinators especially, they're sort of taking the attitude that they're going to get out there and really stop all this stuff and, you know, get the bad guys and whatever else they have in mind. And I think it's really important to recognize that every complaint or issue that comes forward needs to be assessed as to whether or not there's any sort of grounds for the complaint, and also be very clear that you're not taking one side or the other until you get all the facts together. And finally, in cases of investigation, it's necessary to conduct a complete and careful investigation. I think Bill covered some of those issues already. So then, When we talk about training the complaint investigator in specific, I think it's necessary to make sure that the complaint investigator is trained on a lot of different areas. I'm going to mention many of them. And I think for me, I think it's ideal for that to be done in a group setting. So if there's a complaint investigator in every district within a 50-mile radius, maybe they can all get together and be trained so that they have the opportunity to interact with their colleagues and talk over cases and learn from each other. They need to have a thorough definition of the terms that are involved. They need to be able to ascertain that the policies have been thoroughly disseminated and how to do that. They need to recognize and know how to address conflicts as they come up, because investigating in particular is very conflict-ridden, and I think that's very important. They also need to be skilled in handling informal complaints, and I'm going to talk about that just a little bit more in a minute. They need to have a thorough knowledge of federal and state law. They need to be well informed about the Dear Colleague letters that Joyce Harris was mentioning earlier. They need to have skills in how to go about processing the grievances that they receive. They need to be very clear in what sorts of documentation is required for every case, and there's a lot of documentation, particularly in cases where you can find written records and those sorts of things. They certainly need to be trained in skills for investigating complaints and what sort of procedures to follow and what order in which to discuss things with witnesses, etc. I think it's very helpful, and this is why I think a group setting is so important, for case studies to be followed up with so that everyone has a chance to say, well, if this kind of complaint comes forward, how would you investigate that, etc. And finally, I think that complaint investigator training needs to include things like strategies for prevention, which is going to be one of the next things I talk about, and sorts of resources that might be available to help with the prevention effort and with the complaint investigation effort. So when someone is a complaint investigator and they receive a complaint, I think the first thing that should be recognized is that sometimes the complainant does not want to file a formal complaint. However, if you are the complaint investigator or the complaint receiver and you get a complaint, whether it's written or not, you have to follow up on it. I think it's not necessary if this is a one-time event that is being complained about. If it's a minor complaint, it may not be necessary to elevate that to a full investigation level if, and I'm saying if very carefully, if an acceptable solution can be found quickly. One example of that might be a case in which you have objectionable graffiti in a restroom that speaks about an individual person. If that graffiti can be removed immediately and then the situation can be monitored, it may not be necessary to go into a thorough investigation unless it repeats itself. And then if it does, you need to go forward with a thorough investigation. As Bill mentioned, and I believe Joyce also mentioned, it's very important to make sure that any complaint that's received be assessed to determine whether or not it's necessary to take steps under child welfare laws. So I think that needs to be, I've run into a lot of Title IX coordinators and harassment investigators who are not certain exactly what their responsibilities are, and I think that's how you end up in the paper in a really bad way. So I think that's really important. All complaints that are received must be investigated unless, as I mentioned earlier, it's an informal resolution that was made possible. Confidentiality is something that many of the complainants really want to ask about. They want to be sure that no one finds out about this, and I think to the extent possible, you can assure them that you will keep this to yourself and you won't talk about it all around the school, but at the same time, they need to recognize that you have to investigate the complaint, and that will necessitate at least the person who's being accused of the action finding out that this complaint has been filed. And finally, I think that it's very important to make sure that the person making the complaint, and then when you get into investigating the person who is alleged to have committed whatever activity is being complained about, recognizes the policies about retaliation. And I know that both Bill and Joyce mentioned that as well. Excuse me. So the Title IX coordinator, theirself, has a number of roles that they can play that are very helpful in this process. I think the very first thing that needs to be recognized is that most people that receive harassment do not only have one wish, and that is they want it to stop. I think the Title IX coordinator can play a very important role in that by engaging in activities that will be preventative. For example, they can monitor where problems occur when they receive complaints. They can implement prevention strategies in that case, and maybe that will cut down on the amount of complaints, at least about the areas that are being monitored. They can promote the dissemination of the policy in informal ways as well as formal ways, not just posting it up in places, but talking about it. Maybe they could go through the homerooms one room at a time and talk about it. They can go to the community and make sure the policy's out there, et cetera. The Title IX coordinator can advocate for the elimination of bias, and I'm going to talk a little bit more about that in a future slide. They need to conduct an ongoing procedural process so that they're certain that they're following up on all of the processes that are required. They need to at least follow the letter of the law, which is the minimum required, and the ideal is that they would follow the spirit of the law, which is trying to prevent this from occurring in the first place, because as we all know, I think harassment can prevent people from getting a full and meaningful education. So to sum up the part about complaint investigation, I would say that the complaint investigation is only part of the program to prevent harassment and discrimination, not the goal. So the goal is to cut down on harassment and discrimination. I'm not sure you can ever completely eliminate all harassment and discrimination. We're dealing with people here. But I think it is possible to cut down to a very small level if you have a thorough program to prevent. I think you will always have complaints, and they will point you to areas that are problems, and that will then help you focus your long-term prevention efforts. I think a long-term prevention effort in general is likely to decrease the number and severity of complaints, and that, after all, is what we would like. So now what I'm going to do is talk a little bit more thoroughly about prevention. I think it's really important. I mean, I run into so many schools and districts where they do one prevention activity that maybe they do a little half-an-hour presentation somewhere, or they post up a bunch of stuff and they figure, okay, we got that taken care of. But I think a prevention strategy is much more effective if it's comprehensive. It covers all sorts of areas. It's planned for the entire system across the grades for all employees, so that all employees and students are thoroughly addressed by that it's systematic. By that I mean that it's regularly implemented. In most schools and districts, there's a fair amount of student turnover. Every 4 years, your high school turns over. Every 2 or 3 years, your middle school turns over in terms of population. And so it has to be systematic, and it has to be ongoing. As Bill said, careful records must be maintained of complaints. And I think you could include the terms when, where, what, et cetera. Check for patterns. That's what I mean by monitoring. And evaluating, you can then watch your records and your statistics about events that occur and then determine whether your prevention efforts are effective. So if you try a new prevention effort, then you'll know whether it's worthwhile or not. And I think finally, you know, in education, we get really focused on new. It all has to be new. And I think if, in my opinion, it's not necessary for things to be new. I guess perhaps because I've been around doing this for so long, I'm aware of resources that came out maybe a few years ago that are equally effective and useful, and we shouldn't abandon all the stuff that's been out there for a while in the interest of only getting new stuff. So some of the prevention efforts that can be undertaken include prejudice, bias, and discrimination reduction. I think each of us have our own personal communication style. Also involved in that, our own personal communication style is our own personal cultural reference point. Each one of the different cultures in the entire country and world have different styles about what is polite, what kind of wait time is it okay, how much eye contact and what type of eye contact, personal space, what's appropriate in terms of reproval, what gender roles are, what the concept of time is, what our teaching and learning styles are. All of these things are part of cross-cultural communication and understanding and need to be addressed in the prevention effort. Harassment in general is a victimizing behavior, and I think that we need to help everyone in the system understand that and then learn how individuals who are victimizing others can overcome that need. And this is perhaps for some individuals, there's a need for counseling there. I think that each school can encourage students and staff to work on social reform and personal growth issues by identifying what needs to be improved and having projects to work in those areas. And finally, something that I think is very effective with students particularly is myth-busting on a case-by-case approach. Most students that I've run across really get into talking about, well, what if this were to happen, and how would we address that, and what would the bystanders do, and what would the victim do, and what might help the person who's engaging in that behavior to stop, etc. I think those are very effective. Conflict resolution and mediation is another area in prevention that is very helpful. These are all school-to-work skills, by the way, conflict resolution. We're all going to go out in the workforce. We're all going to be working with people who are different than ourselves. Our students need to understand, have these skills to go forth and have an effective career, no matter what career they're going into. Increasing tolerance to decrease conflicts is very important, but I think sometimes people get mixed up in the idea of tolerance and only think about race. Tolerance refers to racial issues, but it also refers to gender and actual or perceived sexual orientation. And these are areas that are particularly important when we get into the harassment prevention area. Students can be taught conflict resolution and mediation skills. There is a conflict manager approach where students are actually trained in how to handle conflicts and how to intervene and be helpful to their peers. I've seen students walking around the playground with clipboards saying, I'm a conflict manager, and intervening when they see others interacting in conflict. And then I think it's also important to encourage students and staff to work towards social and economic justice for all. Finally, violence prevention needs to work towards helping everyone understand violence as part of hatred. Hatred is not necessarily always face-to-face. It sometimes is aimed at property, and I would include in that vandalism or circulating written materials, as well as the graffiti issue. But violence is only one part of a sort of line of hatred issues. I think it's important to understand dating and relationship violence as well as part of that. Students need to recognize skills for anger management, when they can walk away, how they can exit gracefully from a situation, and they need to recognize that violence is and can be very self-defeating. And finally, this is a good place to involve community partners, especially where the staff is racially and or culturally different than the students they're working with. But in all cases, it's really important to get those community partners involved. So to sum up, I guess I must have skipped a slide. I apologize for that. To sum up, the complaint investigator and the Title IX coordinator need to be fully knowledgeable. They need to assure that they're complying with the law. They need to regulate with caution, because I think education is always more effective than regulation. If you have way too many rules, sometimes you never get to the point where you're actually changing behavior. Formal discipline may be the least important thing that can be engaged in preventing harassment. Stopping the harm is the most important thing, and that would be the final takeaway, I would say. So now I'm going to turn this back over to Joyce and let her handle some of the questions.
Hello. Well, I'd like to, first of all, thank both of our presenters. And we are going to open it up now for questions and answer sessions. So do you have, any of you have any questions? You can put them in the chat room. But one of the first ones that we that we've received is, where can one get training on how to conduct an investigation? So which one of our presenters want to respond to that? Bill?
Certainly. The question is, where does one get training in Title IX? And that's absolutely essential for Title IX coordinators. Certainly, too, the Equity Assistance Center should be one of the first calls, because they are the experts in the field. Another group that I am very fond of is the National Women's Law Center, that also provides training in this area. I just want to caution folks who are looking for training is to make sure that the people you contact understand Title IX. Using a law firm is fine, but law firms are very good at Title VII, employment law, but they don't always understand the nuances of Title IX. Also, each regional office of the Office for Civil Rights also provides training, and it's about 2 hours, and they do it at no charge.
And I'd like to also add to that, the Equity Assistance Centers would definitely be a place that I would go because the training is free, and the EACs have been doing this for many, many years. And so I would suggest, and I think we're going to have a list of the EACs as part of your resources. So all you need to do is give them a call. Anybody who's in my region, which includes Oregon, Washington, Alaska, Idaho, Hawaii, and all the Pacific Islands, please feel free to give me a call, 503-275-0664. A little promotion there. Another question that we've had is, what are the penalties for noncompliance? And before I turn it over to one of our speakers, I'd like to say that I think it's important for you to read some of those Dear Colleague letters and get some insight into what OCR looks for in an investigation, and then what they may require of a district or a school that has found to be out of compliance. So one of our presenters want to pick up and add to that. What are the penalties for noncompliance?
Certainly the one that the Office for Civil Rights would tout is that the potential loss of all federal funds. One of the arrangements with every state is that in receipt of federal funds, you must agree to adhere to all civil rights laws. So failure to comply with Title IX means the potential loss of all your federal funding, which, although it's never happened, the consequences are schools would shut down because they cannot operate without federal funding. The other issue is that the Office for Civil Rights, if the situation is extremely egregious, they can turn it over to the Department of Justice, which can fine school districts. But the other part, too, I want to bring up is that when you allow a school district or a school to develop a reputation as not being in compliance in terms of sex discrimination and sexual harassment, it has not only an effect on students, but also has an effect on the town itself. I have had the mayor of a town call me with an alarming concern that real estate agents were calling him and saying, you know, it's harder and harder to sell houses in this town because of the reputation of the high school and the amount of harassment that goes on. So real estate agents can tell you directly that when you have schools that develop a bad reputation, it has a direct effect on property values. So just from a fiscal perspective, towns with that kind of reputation with unchecked harassment, it affects your bottom line in terms of dollars.
Marta, do you have anything you want to add to that question?
I think that was pretty thorough, but I do want to point out also that one of the other things that can happen to a school or district that doesn't follow through on investigating complaints is the private suit. And, you know, I'm aware of cases in which the financial settlement from those suits has been anywhere from $10,000 to hundreds of thousands of dollars. And as Bill suggested in his remarks, that sort of thing can really damage a school district's ability to function.
I also want to add that the other penalty, and not a penalty in the sense of, you know, you have to pay something, but a consequence for noncompliance can be that OCR will closely monitor you for whatever time they deem appropriate. OCR will be very specific in terms of telling you what you must do. Once those findings come out and there is a settlement agreement, then you don't have an option not to do some of the things that you've agreed to. And it must be done in a timely way, and it must be done to the satisfaction of the Office for Civil Rights. So that's kind of like a penalty in a way, in that you become under the scrutiny and guidance of the Office for Civil Rights. Okay, we have another question here. How can you ensure that your school-based investigation proceeds without conflicting with a police investigation?
I can talk.
Can you respond to that one?
I can take that one too. And this is something that does come up. Schools need to be aware when complaints are Title IX or harassment or criminal complaints, and they do have an obligation to notify the police. You know, don't wait for the parent to do it, or don't ask the parent to do it. If a school believes that it is a possible criminal act, they need to contact the police and have them look into it and see if it warrants an investigation. The police department, in many cases, will tell Title IX coordinators, you know, wait till we get our job done first, and then you can do your job. The difficulty with this is that if it takes an inordinate amount of time, and if there is, say, forensic evidence that has to be sent away to a lab and then come back, it delays the process. And so the longer you delay, the longer alleged perpetrators get together and get their act straight and get their story straight, people's memories fade, and so on. My advice is to develop a very good working relationship now with your youth officer or police department to have an understanding of how long you plan to wait. You know, a week? Is that a reasonable amount of time? Possibly, depending on the severity. But that needs to be discussed with the local police department now before you have a case, and then end up in a struggle about who gets to go first.
And then, of course, ultimately, it's the safety and well-being of the student who has been the target of the behavior. Certainly, if there's a situation where that student will be further victimized by whoever has committed the act or has infringed on their rights to a safe school environment, then you must take some action. And as Bill was saying, that is something that you need to make sure you have a good working relationship with your law enforcement to do that. And if necessary, you may have to go to a police chief or to whoever the commissioner is and just say, this is the situation and we need to move on this. So we need you to either accelerate what it is you're doing, but understand that we have a legal obligation under federal laws to act as well. So there's a question, what resources would you suggest for informing students of their rights under Title IX? You can always go to, once again, the Equity Assistance Centers, because we have resources and many of us do work with students. We also suggest that you go to the website, stopbullying.gov. They have tons of materials there. And then finally, the National Bullying Prevention Center, PACER, they have materials for students. And as a matter of fact, gives it a plug, October 9th, Wednesday of this year is National Bullying Prevention Day. I strongly recommend that you go to the PACER site, National Bullying Prevention Center, and there's just a series of different activities that students can involve and they can initiate and they can implement. So I would suggest that. Before I forget to do this, you will be receiving a survey after this webinar. Please complete it for us. It would make our evaluators just ecstatic, and it would make all of us happy if you could do that. It's not very long, but we would appreciate your feedback. And we use your feedback because it also helps us to plan all future webinars that we plan to do. So what you're seeing now is a list of the regional equity assistance centers. And if you click on them, you'll be able to see which EAC serves you. Or they can't see it. Okay, you can't see it. We will. Well, you can go to it. You can just Google your EAC, and then it'll tell you a little bit more about what states they serve and where they're located. And someone wanted me to repeat my contact information. It is 503-275-0664. And I think there's a slide that has my contact information on it at the very end. There you go. I'd love to hear from you. Even if you're not in my region, I'd love to hear from you. So we want to just thank everybody for being a part of this. And please feel free to send us emails even when this is over. If there's any information or any clarification that you need on something that was presented. And, of course, you can feel free to contact our presenters, Martha Larson and Dr. Bill Howe. I want to thank you very much for spending this time with our audience and sharing the information that you have. And we hope that maybe you'll join us in some future webinars, because we're considering doing another one as part of this on Title IX, but looking at it from the perspective of it's not just athletics, because we often forget that. So thank you so much, and we hope to be in touch with you in the future. And like I said, please don't hesitate to get in touch with us if there's anything we can do, any materials we can send you. And once again, thank you to Vicki Nishioka, who's been one of the coordinators of this, pulling it together. She works here at Education Northwest as a Senior Research Associate. And then Mitch Rymiski, who is our IT person. And were it not for Mitch, I tell you, I don't know how we would have gotten through the morning. So thank you so much, and I hope everyone has a safe day and a good day. Bye.